This lecture looks at the unfortunate prevalence of myths around sexual assault against our first Australian women and how their Aboriginality and gender come together to uniquely position them as being available as objects of sexual assault, not only to white men, but also sometimes to men in their own communities. These cases represent some of the case law in which the intersectional positioning of Indigenous women led to the discounting of sexual violence against them. In the first case there, Bert Lane, Ronald Hunt and Reggie Smith, the case involved three men who approached an Aboriginal woman who asked them for a cigarette. The evidence given on behalf of the men was that rape was not considered to be particularly serious in Aboriginal communities, that asking for a cigarette may have been coded as a willingness to engage in sexual activity. The three men sexually assaulted and raped the woman. There was counter evidence by female anthropologists that in fact was not the case in the women's community and the local community, but rather that local First Nations women took sexual assault and being sexually demeaned or treated poorly very seriously and would arrange punishments for men who treated women in such ways. However, the judge found, as you can see there, in favour of the evidence that rape was not serious and that asking for a cigarette was sufficient consent, to say that there was evidence before him that I accept that rape is not considered as seriously in Aboriginal communities as it is in the white community, and that indeed the chastity of women is not as importantly regarded as in white communities, and the men were actually found to be not guilty. A similar case of Minkili, Martin and Mintuma from 1991, 11 years later, from South Australia, involved a situation in which a woman was incarcerated. The men involved were men who were police officers and also Indigenous support staff for the police. The three men raped the woman who was incarcerated at the time. The only evidence of local attitudes to rape amongst Indigenous peoples was by another police officer, a Sergeant Berry, and the judge found that forcing women to have sexual intercourse is not socially acceptable, but it is not regarded with the seriousness that it is by white people, and therefore the men were not guilty. Because even though this, as he clearly acknowledges, is a crime under South Australian law, it was not a crime or not serious because the victim was a First Nations woman, and her indigeneity and gender meant that such a crime against her did not count as a crime and did not count as serious. Part of these things come from a myth of sexualisation of our Indigenous women that paints them as sexually available, not only to colonisers, but changes often the perceptions of the law in their communities. Another situation which occurred in the case of Pascoe and Hales, but which was fortunately overturned in the case of Hales and Jamal Mirror, was one where Pascoe, an adult man, well over the age of 18, had married or claimed he had married an underage girl. She was only in her early teens. He was arrested and charged for sexual offences against this underage girl, and his defence was basically that he had married her according to traditional methods in which he claimed she had been given to him. And at the first instance, the judge actually stated that this young girl, a child, didn't need protection from white law. She knew what was expected of her. It's very surprising to me Pascoe was charged at all. Again, the presumption that because while there may have been differences originally in our First Nations law, that the actual actual current law of the land around sexual assault on minors would not apply to a girl because, quote, she knew what was expected of her. She knew that it was expected that she would be raped by an adult man even though she was underage. This was, of course, as you can see, they're overturned in Hales and Jamal Mirror. Jamal Mirror was another name used by Mr. Pascoe. It was his a traditional name, and he's shifted from his from the European-based name of Pascoe to his original name between the cases. And they said that in that case the law applied to all offences equally, and that an offence against a minor was still offence against a minor, even though before colonialisation there may have been different views of the fact, but that now all children, including Indigenous children, should be protected. Some cases, however, have done better, and you can see a list of them there, and they actually rejected such arguments. But as you can see, as late as 2003, these arguments were still being accepted at trial. Part of this comes out of what many Indigenous scholars, and particularly female Indigenous scholars, call bullshit law. They talk about the colonial law, that is the law imposed by Europeans, traditional law, and then bullshit traditional law. Bullshit traditional law is a concept of law where offenders may assert that there was a traditional law, often in the context of violence against women, domestic violence, and sexual assault, that this was allowed under previous laws. And because of certain racist stereotyping of Indigenous women, they may be accepted even in the face of competing evidence, as in the first case on the previous slide, that this was the likely arrangement, that men could enact violence against women with impunity, and that therefore both Indigenous and white men could enact violence against Indigenous women with impunity. And as you can see, Sharon Payne calls this a distortion of traditional law used as a justification for assault and rape of women. It's ironic that the imposition of white man's law on traditional law have resulted in the newest one. And often these ideas actually adopt the 18th and 19th century positioning of women by white men as lesser, something that is being addressed now in European society, but which was actually in many cases not the case under previous traditional laws, and that's why it's called bullshit law. Mick Dodson himself also has said some of our perpetrators of abuse and their apologists corrupt these ties, that is the ties of Indigenous tradition and law, and our culture in a blatant and desperate attempt to excuse their abusive behaviour. And it is far too often accepted by courts, unfortunately. Larissa Behrendt, in the 2004 Claire Burton Memorial Lecture, said that, talked about the rise of these traditions, that Aboriginal women are easy sexual sport, and those notions have also contributed to the perception that incidents of sexual assault are the fault of Aboriginal women. For example, if you consider that first case, a woman asking for a cigarette is at fault or is somehow seen as having provoked sexual assault against her. And while behaviour and treatment of Aboriginal men is often contextualised within the process of colonialisation, no context is provided for the colonial attitudes that have seen the sexuality of Aboriginal women demeaned, devalued and degraded. The result of these messages given to Aboriginal women by their contact with the criminal justice system would only reinforce any sense of worthlessness and lack of respect that sexual assault and abuse have scarred them with. And for this reason, once again, many First Nation women are loath to engage with our criminal justice system, seeing that not only does it tend to over-criminalise their people, but also offer little or no protection for them. And you can see there, as I mentioned, it was still an issue that came up again relatively recently, when Trevor Noah, the comedian and a talk show host in the US, was going to tour Australia, someone had pointed out that in 2013 he had made some very distasteful jokes about Australian First Nations women, basically saying they're unattractive but sexually useful for men. He has since apologised for this and said he was wrong, but it was interesting that an allegedly progressive black man known for addressing racism in South Africa and the US was perpetuating certain racist stereotypes of our First Nations women.